Thank you. Can I ask the panel to elect a chair, please?
Yes, thank you, Lucy. First item of business is to elect a chair. Do we have any nominations? Patrick?
Nomination, Councillor Ross.
Thank you. Seconded. Thank you. So, thank you very much. So, I've been elected as chair. Good morning. Welcome, everybody. My name is Councillor Jo Robb, and I'm the chair of the panel today. Councillors Catherine Keats-Rowan and Kelly Hinton are joining me on the panel. I have a few statements to make before we proceed. Please could everybody make sure that your phones and computer devices are switched to silent during the meeting. In the event of a fire or a fire alarm, the Democratic Services Officer, who is Candida, will lead us all outside the building where we should remain until we're told that we can return, and the meeting will resume once all attendees have returned to the meeting room. If you have a question to ask during the meeting, please could you raise your hand to alert me, and please do not speak unless you're invited to do so, and please do not interrupt other speakers. And good morning to everybody joining remotely. When you are not speaking, please can you ensure your camera is switched off and your microphone is muted. Are there any questions on this or any other matters for today? Okay, great, thank you. So the procedure for the meeting has been included in the agenda pack. Has everybody understood the procedure for today? Great, thank you. And just a reminder, because we have a large number of people speaking today, ordinarily each party category would have a maximum of 15 minutes to speak. So that is 15 minutes for the applicant, 15 minutes for the council, and 15 minutes for other parties. But I'll be flexible with that today, but please, if we could try and avoid duplication and repetition, that would be great. So this application is for a premises licence for Nappa's store on the High Street at Goring-on-Thames. I'll now begin the item, and I invite the licensing officer to present her report, please. Thanks, Ashley.
Chair, can you just look at the rest of the agenda? There's the declaration of interest.
Oh, I beg your pardon.
It's okay.
Are there any declarations of personal pecuniary interest?
No, none.
No, there are none.
Yeah. Everything? Brilliant.
Yeah. Thank you.
Thank you.
Chair, the application before you today is a new premises licence application for Nappa Store High Street, Goring-on-Thames. The applicant is Mary Gaylor. The application form can be found in your report bundle from page 17. The application seeks a supply of alcohol Sunday to Tuesday, 9 AM to 7 PM, and Wednesday to Saturday, 9 AM to 11 PM. The applicant is represented here today by Mr. Gary Grant, barrister of Francis Taylor Building. During the consultation period, the application has attracted 19 representations. 2 representations raised objections to the application, and 17 representations were submitted in support of the application. No representations were received during the consultation from any of the responsible authorities. The representations can be found in your report pack from page 27 onwards. The council has been notified that Sally Wicks, Olivia Jones and Dr. Louise Axon are in attendance remotely to speak to their representations. Evan Holland and Amy Holland, Ron Bridle, Brian Urbeck and Virginia McMurtry are in attendance to speak to their representations. We have not received any notification that any other persons are in attendance today. We are aware that there is a planning application currently in progress. I must raise that the planning application and the licence application are part of separate regimes, and all matters relating to the planning application not for consideration for this panel.
Just a minute, actually. So does your hand relate to a specific point of clarification?
Yeah, it is in regards to the statutory consultation of other authorities with regard to environmental health. Though you haven't received anything, there was an error on addressing.
Yeah.
So
we'll come to that.
Yeah, okay.
Thank you. Go ahead, Ashley. Thank you.
In considering the application, options available to the panel are to grant the licence applied for, to grant the licence after modifying any conditions to such extent as the authority considers appropriate, exclude from the scope of the licence any of the licensable activities to which the application seeks, to refuse to specify a person in the licence as a premises supervisor, and or to reject the application. The attention of all is also directed to parts of the council's licensing policy, which sets out how the council must deal with the applications, and also the relevant parts of the Secretary of State's guidance, for which the council must have regards to when carrying out its licensing functions. I can confirm the application is advertised in accordance with the Licensing Act 2003, hearings regulations, and I have nothing further to add at this stage.
Thank you very much, Ashley. Does the applicant, beg your pardon, members, are there any questions for the officer? No. Okay. Does the applicant have any questions for the officer?
No question.
Thank you. Do any other attending parties have any questions for the officer?
No.
Okay, thank you. So there being no further questions, I'll now ask the applicant to present their case. Thank you.
Councillors, last night, to ensure I wasn't late today, I stayed locally next door at the old Abbey House Hotel. And above the door are these lines from the poet Alexander Pope. Through this wide opening gate, none come too early, none return too late. Now, this is a case where you will, in fact, be conditioning how early and how late people can come to my client's premises if you give them permission to go ahead. But the point is this, it's about hospitality. And my client, Mary Gaylor, can put before you a wealth of testimonials from a long track record of expertly, professionally, and responsively running licensed premises on Goring High Street. She spent 8 years running the large 200 capacity plus pub 5 doors away, Miller's of Mansfield. And she did a spectacular job from turning it into a venue that had caused problems into a venue that became the centre of the community of Goring. And it is those who know her and know how she runs premises in a way that ornaments the village rather than disrupts it, in the way that she has behaved like an exceptionally good neighbour to the residents who, similarly to her new venture, lived cheek by jowl with the pub. That is the reason you have extraordinarily 17 mainly locals writing in support of the grant of this licence, because they know Mary and they know what she's capable of doing. Now, what she hopes to do is to turn a vacant high street premises that for some years operated as a beauty salon, but for 100 years before that was associated with the supply of alcohol. It was W.H. Napper's store, which it was a liquor license and convenience store for some 100 years. What she hopes to do you will know the plight of high streets up and down the country, and Goring is no different. Rather sadly, this glorious village now has 4 vacant retail premises on the high street. What Mary wishes to do is to turn this vacant premises into a venue that is of service to the community and does not undermine any of the licensing objectives. Now, the vision is to have a small bottle shop and wine bar. The bottle shop, just to give you an idea of numbers, bottle shop will have 24 covers seated. The wine bar is a maximum of 20 covers seated. And there is a private meeting space upstairs. It will be things like for book readings or for a private dining experience upstairs, 12 people seated, or if it's a standing event, 30. So this is a small premises, certainly compared to the Miller of Mansfield 5 doors away. The hours being sought are modest. Sunday to Tuesday from 9 a.m. to 7 p.m, Wednesday to Saturday, 9 a.m. to 11 p.m. Those hours are within your recommended hours policy, within your statement of licensing policy. And for your lawyers note, it's paragraph 6.11, but you'll be familiar with it. And it's where your policy, which carefully have been consulted with all relevant parties, tries to draw the balance between what is the reasonable expectation of commercial operators balanced against the reasonable expectation of residents not to be unduly disturbed. And it suggests that the noise will be of greater importance after 11 p.m. and before 7 a.m. So we are within your recommended hours within your policy. This is not going to be some raucous wine bar. What is intended to be is that members of the local community, because that's who it's going to serve, will be able to enjoy a fine wine in convivial circumstances perhaps with a charcuterie board or other light bites. It's not a restaurant, but it is a place for a civilized drink among friends and neighbours. And just about all of our clientele are expected to be our neighbours. There will be no live music. There's been no application for regulated entertainment of any sort, so recorded or live music. Now, before 11 p.m, it's not actually necessary to have specific permission to have music. So I can indicate, and this can be an undertaking to be recorded if you're minded to grant this license, that the only music that will ever be played, even before 11 p.m, even though it isn't licensable, will be at background levels. It will be at a level where people can have a quiet conversation over a glass of wine without needing to raise their voice. Although it's not licensable, I give that undertaking, it will be minuted, and if you ever breaches that, you can come back to the minutes today. So this is not going to be a lively wine bar, in fact, much the opposite. There has been, and this is important, no objection from the police on crime and disorder or antisocial behaviour grounds. Now, there is a curiosity with the Environmental Health Officer in that although they were properly served with this application, they made no representations. They made a late intervention in a rather unorthodox manner, and I've addressed submissions to your legal advisor on that. I can say this, that we have engaged with Mr. Morgan, the Environmental Health Officer, and it's led to 2 agreed conditions, which I'm offering over and above all those at your Appendix U in your agenda papers. And these are in deference to the concerns of the immediate neighbours, Mr. and Mrs. Evans, and also Mrs. Virginia McCurtry. And their representations are at page 27 and 37. And those conditions, in addition to all of the other conditions, are as follows. This is set out in the email that Ms. Basilio distributed on 13th of December at 3:27. Number 1, that the licence holder shall, in consultation with the Environmental Health Officer, implement a written dispersal policy designed to ensure that customers leaving the venue do not cause a nuisance to residents living in the immediate vicinity of the premises. And 2, prior to licensable activities being carried on at the premises, and having consulted with the council's environmental health officer, the licence holder shall implement noise mitigation work so as to prevent a statutory nuisance to the nearest noise-sensitive residential premises. Now, what those conditions do is they ensure that if you are to be persuaded to grant a premises licence, the premises cannot operate until whatever is done to the premises, whatever plans are done for dispersal, are approved by your environmental health officer. So today is, although we've seen some noise reports coming to and from in a game of, it seems, acoustic ping pong, that is not something that needs to trouble this committee for 2 reasons. 1, the precise nature of the acoustic mitigation works that need to be carried out, and they are possible, says our report, will be a matter for planning. It won't be a matter for this panel to decide exactly what acoustic works need to be carried out, but your colleagues in planning will have that opportunity. In addition to that, as well as whatever planning decide, anything we do must be cleared by your expert noise team in the form of your environmental health officer. So you'll be pleased to hear we don't need to get into arguments about how many millimetres certain acoustic insulation needs to be. That will be for the planning colleagues. Your role here is more a matter of principle, focusing on the licensing objectives. Now, the licensing objective, if we put aside crime and disorder, on the basis that your experienced police licensing officers, if they have any concerns at all, would be here today, and they're not. It's really public nuisance. That is really the only concern raised. And I'll emphasise the word public nuisance. Licensing is only concerned with public nuisance. It is not concerned with a private nuisance that may or may not be of concern to the nearest residential resident. That is not an expression in callousness. Mary will and has a long experience dealing directly with residents who live next to licensed premises she's operating. She will do whatever is necessary to be a good neighbour to Mr. and Mrs. Evans and to Miss McMurtry, in order to ensure, firstly, there are no issues, and secondly, if they do arise, and something always arises in any premises, she will be responsive and responsible and deal with that, and she will pass on a personal phone number so immediate steps can happen if there's ever an issue with her neighbours. So bearing in mind, licensing is not here to deal with private nuisances. The conditions we've offered are in deference to Mr. and Mrs. Evans and the concerns of Miss McMurtry, the nearest adjoining neighbours in this case. And I can offer an additional condition that is designed in this case to give even further comfort to the nearest residents. And that is to add a condition that is the standard condition that Westminster Council, that was more licence applications than any other authority in the UK, puts on many of its licences. So can I read this out, because I haven't yet dictated. No noise generated on the premises or by its associated plant or equipment shall emanate from the premises, nor vibration be transmitted through the structure of the premises, which gives rise to a nuisance. So I'll read that once more for your notes. No noise generated on the premises or by its associated plant or equipment that emanate from the premises, nor vibration be transmitted through the structure of the premises, which gives rise to a nuisance. And that means, together with the other two that I've mentioned, that anything that is required to be done by my client to avoid a nuisance to the nearest residents or others, she has to do in order to operate it. A concern was also raised about timings of deliveries and whether they might cause disturbance. I can indicate my client would agree to a condition that there shall be no deliveries to the premises between 6 p.m. and 9 a.m. So in other words, the twilight hours, which can be sensitive, there will be no delivery trucks arriving at that time. Now, 17 supporters, and some of them are here today to speak to you directly. Most of them are Goring residents. They also make this point. The high street itself is not a monastic enclave. It is the retail and hospitality centre of the village. It already has a restaurant, has a pub, has a late night opening convenience store. So this is not a venue where opening a very modest wine bar and bottle shop is going to change the nature of the street. It is the commercial centre, and those who are privileged enough to live on the commercial centre have to live and know that they will live keep in jowl with retail premises. The supporters themselves talk about this premises as being welcome, to being modernising and to reinvigorate the village. And a lot of them have mentioned that having a presence open a little later at night actually helps the security of the street, because it means you have a responsible professional presence there rather than the street being left open to those who may get up to mischief. Commercial need or oversaturation, which has been raised by the objectors, is an irrelevant consideration in licensing. And for your lawyer's note, it's the Section 182 guidance at 14.19. You have our noise report indicating works can be done in order to ensure there's no noise disturbance. If there's a dispute, that's a matter for planning. And the conditions we've invited you to add will in fact deal with that anyway, because we cannot open unless what is necessary to be done is done. Miss Gaylor, you've heard lots of testimonials about her. She is a local, she's a villager, her kids were educated at local schools. Her engagement letter to the objectors, you can see at page 64 of the agenda papers, she wishes to engage and to talk. And I'm going to leave the last few minutes, if I may, just for Scalar to explain to you what she hopes to achieve.
Yes, go ahead.
I just really wanted to share my vision of what I see Nappers to be. As Gary explained, there are three elements to it. So initially there's a shop, which will be open during the daytime for takeaway sales and tasters and wine talks. I'll be using local supplier of 10 years or more to work with, as I have done over the last many years. And there'll also be the option for glasses of wines and nibbles throughout the daytime from around the 12 o'clock mark. Upstairs, I envisage one round table that's there for options such as book clubs, corporate meetings, working areas, and really a community hub for anybody in the local area that wants to use a community space, and as well as wine experiences and hosting dinners. Then downstairs, there will be a wine bar with 4 tables. It will have table service to eliminate too much noise, and it will be by bookings only. And I envisage people wanting to be there for around the 1 to 2 hour marks for pre and post dinner events and catching up. Again, I'll be using some local food suppliers as we've created relationships in the past and managed to maintain those as well. I really want to run this locally again and to operate in the village. I've missed being in the village for the last 4 years, and I feel very supported by the local community. The model only really works in this village for me due to my relationship with the local customers, and I also feel that the majority of the business will be the local customers. Again, I've had a relationship with them for a good amount of time, and during my experience in my 8-year tenure at the Miller of Mansfield, 6 doors down, I had very limited issues there and created great relationships with all of my neighbours and businesses alike, as well as the publicans as well. And I feel that this is illustrated in the representations here today. I feel that unlike some of the businesses that are already there, it'll be something different to offer locally. It'll include tasting experiences as well as intimate corners and small tables where people can savour a glass of wine with only the background music that Gary mentioned, as well as pre and post dinner drinks. I really am passionate about making this work. I'm really quite committed to going ahead. I'm very open to having conversations with the neighbours. As Gary mentioned, I'm very happy to share contact details so that they would have them at any opportunity that arise, any situations that arise. I do only live 5 minutes away from the venue and have been a resident of Streatley for the last 10 years. I intend for myself to be in the business. The majority of the time it will be run by me as the main focus, with a maximum of 2 to 3 members of staff if and when needs arise. And at least the majority of those will also have industry experience as well. And I'd just like to finish to say that I wish you would consider my 8-year tenure and my relationships with local businesses, neighbours and publicans. Thank you.
Thank you very much. Do any members of the panel have questions for the applicant? No? I just had a very quick question around the voluntary undertaking to do with background music at background levels. Obviously that wouldn't be enforceable by our council, but I wouldn't anticipate live music or loud music. It's not a nightclub, is it?
Absolutely not. There'll be no live music whatsoever.
So I wonder, I appreciate the voluntary undertaking, but I wonder, given that it wouldn't be enforceable by our council, we couldn't condition that in any event.
You're right. The law says you can't condition it.
Yeah.
But, and this is a big but, if for any reason my client goes against her word, which she never has before in her professional experience, and suddenly decides to invite the Rolling Stones to play in Goering and causes a nuisance, then any party, including residents, can review her premises licence. At that stage, you can remove the exemption, the deregulation of music exemption. So if she ever went against her word, your officers and indeed any resident have the power to remove that legal exemption.
Okay, thank you very much. And so we have the 2 conditions that you proposed last Friday.
Yes.
With the addition of the new standard Westminster Council conditions.
Yes.
So
And
those
the deliveries. And the no
and the
deliveries.
deliveries, yes, so that's 4 conditions in total.
Yeah.
Okay, thank you very much. Do any other relevant parties have questions for the applicant? Or if there are no more questions for the panel? No? No, thank you. Do any other relevant parties? Oh, beg your pardon, I apologise, licensing officer. Ashley, do you have any questions for the applicant?
No, I don't.
Thank you. Do any other relevant parties have questions for the applicant? Do you mind stating your name? Please?
Sorry, it's actually Evan Holland.
Oh, thank you.
So
Hello.
not
Hello.
Mr.
Yeah.
Evans. Is it part of my turn to give my?
You've got
It's
questions.
just
It's a question.
No, it's just obviously in regards to the acoustics. I mean, actually, no, I'll leave that for another time. Actually, no, I don't need them.
Sure. Are there any other questions for the applicant? No? Okay, thank you very much. So now we move on to other parties. And I believe we've got parties here to support the application, and we've got other parties objecting to the application. Shall we start with objectors? Is that the normal?
Is that, I think it's not in our procedure.
I've got
No.
supporters and objectors.
Okay.
And but if you want to do it, you've got no around it.
Would any of the supporters, I appreciate if you could stick to 15 minutes maximum, but would supporters like to make any representations at this point? Yes, Mr. Irving. Hello. And Mr. Bridle. Yeah. Go ahead, please.
Thank you. Thank you, everybody. I'm Brian Erbick, and though I'm a long-serving Goring Parish Councillor, of course, I'm here speaking in a personal capacity. My partner, Abel, and I own Napper Store, and if successful today, Mary Gaylor will lease premises from us. We're local residents, and 8 years ago, we wanted to purchase the building to support our community and help support the thriving high street local centre. As residents of Goring, we have a vested interest in high street success, not just about selling or renting the space. When Mary approached us about leasing our building to be used as a bottle shop and wine bar, Abel and I were enamored with her passion and with her vision, and could clearly see that a wine bar would be a fantastic addition to the high street. And we've been told by many residents that they like the idea of the wine bar and they think it's perfect for Goring. Therefore, I want to briefly speak about 3 statutory licensing objectives: prevention of crime and disorder, public safety, and the prevention of public nuisance. And I'll do it all in one lump. In the House of Lords report, High Streets Life Beyond Retail, which was published 2.5 weeks ago, it indicates the current challenges of and potential solutions for local centers, and they eloquently discuss that. I recommend you have a look at it. It's quite good. A quote: "Having a well-maintained and busy high street with a variety of uses supports local businesses. Greater footfall for any reason is likely to lead to more customers." And it goes on to say, in contrast, an unappealing high street and a series of vacant units can deter visitors and risk being a spiral of decline for the remaining businesses. And I would reiterate that the Goring Local Centre struggles to fill vacant premises. When we learned that Napper Store tenant wouldn't be renewing, we contacted 4 commercial estate agents, 3 of which said, "We won't have anything to do with Goring. It's too difficult." So sadly, if this application is unsuccessful, it's likely that Napper Store will continue to be one of those vacant shops. Back to the House of Lords report, it says alongside planning, licensing decisions also have a real impact. And in the report's summary, it says celebrating the local history of a place and conserving and repurposing historic buildings on the high street wherever possible celebrates the character and heritage of the high street, encourages a greater sense of pride in place, and could draw more people in and potentially increase footfall. Research around the world, and you will have seen much of this, consistently shows that economic success and pride in place are key driving factors in the prevention of crime and disorder, public safety, and prevention of public nuisance. The plethora of vacant spaces in Goring damages the high street viability and works against this panel's statutory objectives. I reiterate from the House of Lords report, having a well-maintained and busy high street with a variety of uses supports local businesses. Therefore, I would respectfully suggest to the panel that in order to best deliver those three objectives, a license for wine bar and bottle shop be granted to Mary. Thank you.
Thank you, Mr. Irving. I think we might go through all of the speakers now and then have questions at the end, if that's all right. Yeah, Mr. Bridle, do you want to make a representation as well?
Yes, thank you. Well, good morning, and I'm Ron Bridle, and I'm speaking in support of Mary's application. Please excuse me for reading this, but my memory is unfortunately not what it used to be. I should preface my comments with why I'm supporting Mary's efforts to open this new business. Some of this has been said before, but not quite in the same way. I've known Mary for over a decade, and for much of that time, when she and her husband ran the Miller of Mansfield, just a few doors away, since 2014 to 2022. Mary and Nick very quickly transformed this establishment from what was often a rather noisy, run-down pub and restaurant with rooms above to a smart and elegant 13-bedroom hotel with excellent restaurant and well-managed bars that front onto the high street, and it won a number of prestigious hospitality awards. At no time during their tenure were there any problems reported of noise and nuisance to neighbours. Indeed, their management of this hotel brought credit to the village and much needed visitors who came from some distances to dine there and enjoy their hospitality. As a result, Mary made a number of friends in the village due to her support of local charities and consideration of the needs of the customers, staff and neighbours. So to the licensing objectives in question. Firstly, crime and prevention of crime and disorder. Crime and disorder in Goring High Street has historically been extremely low, and I would say almost non-existent, having lived just off the High Street for 25 years and elsewhere in Goring for a further 15 years. I've checked the archives, and there have been no crime incidents in Goring High Street reported by Thames Valley Police for many years at least. I've checked back 4 years of our police reports, and there haven't been any at all in Goring High Street. I believe the addition of this small business is highly unlikely to change these statistics, especially once the measures planned to avoid crime and disorder by Mary are implemented. I understand there will be no after-hours service after 11, an alarm system will be fitted, alcohol will be locked away, and no money will be left on the premises. Also, Mary has practical experience in managing other and much larger establishments than the proposed new one, and therefore the awareness of all the situations which could lead to problems and disorder are well thought through. Second, the protection of children from harm. The few children that are likely to visit the premises will be observed at all times to ensure they come to no harm. With respect to underage purchases of alcohol and drinking, Mary has many years of first-hand experience of running a hotel and bars, and will be fully aware of the need and importance of closely following the Challenge 25 policy to check for underage drinking. Having young children herself, she's also fully aware of the potential dangers and will without doubt do everything necessary to protect children from harm. We've talked about the prevention of public nuisance. No inebriated people will be served for their own and everyone else's benefit and to avoid nuisance to others. Deliveries, as we talked about, will be in reasonable times and notices will be displayed. Customers to be quiet on departure in the evenings, and systems will be put into place at the back of the building to avoid noise, which could adversely affect neighbours' right to peaceful enjoyment of their homes and gardens. Good relationships with neighbours and other members of the public are essential for running a successful business, in a high street in particular, and being a good neighbour. Mary, I know, therefore, will invest all the time necessary to prevent any public nuisance. Fourth, public safety. correct storage of bottles and so forth will be followed. Installation of CCTV will be a deterrent for people walking around the back. And Mary is fully aware of all the issues regarding public safety, as she's been in the hospitality sector for over 30 years and is a consummate professional. Mary will instinctively, therefore, be acutely aware of all the issues of starting up a wine bar in a high street, especially the potential concerns of her new neighbours. I'm confident that the concerns of noise and public nuisance, which are reasonably expressed by neighbours, will not materialise due to the diligence and forethought of Mary about all the issues mentioned. I cannot think of a better and more professional and suitable person than Mary Gaylor to run this new venture. Finally, I would just like to make one general point, rather already been made, which I believe is relevant, and that is the need for new businesses in Goring High Street. The demise of British high streets are well known. There is another shop vacant right across the road and directly opposite. And there are two other high street empty buildings, including a pub that closed 2 years ago and is still up for sale. It's rather sad. Goring is, as most other communities, needs to have a thriving high street which supports the local economy. Although I would not support any business just to fill a vacant premises, for instance, a vape shop or a betting shop. But a small wine bar, I believe, would be a very suitable and welcome addition.
Thank you, Mr.
Goring High Street has always been the beating heart of our community, and I believe it's important to look holistically at the pros and cons of a new start-up to help avoid the risk of more retail premises ending up as conversions into office accommodation or residential use.
Thank you very much, Mr. Brady. Mr. Holland, did you want to speak now, please?
Yes, thank you.
Thank you.
My name's Evan Holland. With my wife and young family, we live at Nappers Cottage. Nappers Cottage is a Grade 2 listed building. It's a timber frame property with brick infill panels. We've lived there for 10 years, and we've enjoyed our time at in Goring. We've lived side by side with Virgo Beauty for that 10 years, and it's been a very good experience. We've never had an issue previously. The problem is that we have a unique situation where our property is a prime freehold over the retail unit. Now, my wife can contest that when she was breastfeeding our children, she can hear a standard conversation through that wall on the first floor, and that's why we are so concerned with the wine bar element. To be clear, we're not objecting to a business, and we would welcome a business, and I think it would be helpful within the local community and for our own benefit to have people using that retail unit. But it's the wine bar element and the times that have been given that have caused us most concern. I think I've taken. You've probably seen this as I've added in our situation. So that's.
Mr. Holland, would you be so kind as to bring it nearer to us?
Is that right?
It's
So
not
do I
for me
talk
to
to
see
these two as
anyway.
well?
Thank you. Thank you very much. Okay.
So I'm going to try and that as well.
Yeah, got
So-
that. Thanks.
You've got the pictures there. So our bedroom goes over that unit below. As you can see, all that's there at the moment is our joists and our floorboards, and that's the only current protection of any sound mitigation. Now, I know that there's been a sound report done. Unfortunately, it's a bit disappointing that no actual acoustic testing was done. At the moment, the acoustic report only gives an estimate or a guess of what the actual build-up is and what the assumed dB rating between various fabrics. I was expecting, and that's when I was allowed to the acoustician to come in. I was expecting a full acoustic report, acoustic testing to be taken place. So if the applicant does put in the mitigation, we don't actually know whether that's actually going to work. So I would have suggested that we have acoustic testing beforehand, so we know and we've got a baseline. And afterwards, once all the mitigation has been done, to prove that it has worked as what's been intended. It's actually disappointing to note that only today have I actually heard of what the rooms are going to be. We've had no engagement between obviously the landlord or the applicant during this whole process. So I'm just a bit flabbergasted that obviously we've had very, very good glowing reports of how the applicant will engage with the local community, but this is the first time I've heard that there's going to be a dining experience up on the first floor, or that there's going to be some reading areas. And I think that comes through within the application. It's just very vague. There's no drawings, there's no plans, there's nothing telling me what the actual it's going to be. I don't know where the bar is going to be located. I don't know what the bottle shop's going to look like. It's just all very vague. Sorry.
Take your time.
It's been obviously quite a lot for us to take on board. And we feel that we've been on all fronts, from a application for the licensing and an application on the planning. And we're having to fight on two fronts. And I'm trying to make everyone aware that we are living above that. We're happy to work with everyone, and when we're willing to talk and work together. But no one seems to be listening or engaging with us during this whole process, and that's what's been generally upsetting. Again, with the deliveries, this is the first time we've heard about what's going to happen with the deliveries. We don't know where this CCTV is going to be placed. We don't know what storage and recycling is going to be happening. We don't know the recycling when. Our main concern again is the acoustics, and even though that the licensing will finish at 11 and no more alcohol will be served at 11, there's going to be what I would have assumed at least another hour worth of clear up and bottles and glasses being collected. And that's what's generally concerning us. And with the bottle shop, we're expecting people, unfortunately, are very lazy. And we're expecting that people are going to be driving in for a quick visit to pick up their casements, and they will be parking either in our parking spaces or will be blocking us in. There's very limited room. Sorry, let me just put some more plans here. Just present those.
Yes. We've got,
You've seen those.
No, but please bring them, because it's helpful to see them in colour and full size. It's much more difficult on a small computer. Please bring it, my goodness.
So again, it was just.
Yeah, great, thank you. So this is okay.
Well, these photographs, these are the ones that have been circulated.
They're within the report, yes. So they're just duplicates.
So there's nothing.
There's nothing
no
new.
new material.
There's no new
Okay, thank
everything's
you.
in my initial.
Because we're not
submission.
allowed to have new material at this point.
Okay,
So this.
Yes, no new material from us.
Thank you.
So finally, just obviously again with the mitigation, it's good that obviously there's some mitigation that's been proposed, but again, as I've stated, Nappers Cottage is a grade 2 listed property. Anything that does get proposed will need a listed building consent. So now we've got a licensing application, we've got a planning application, and now we're going to have to go through a listed building application just to make this work. Don't think about anything else. So I think I've tried to cover as much as I can. Thank you.
Thank you very much. Are there any other speakers or people here today who wanted to make representations? Hello, good morning. What's your name, please?
Virginia McMurtry.
Oh, hello, Ms. McMurtry. Yes, thank you. Go ahead, please.
Sorry if it overlaps.
Not at all. No.
Just some background information. I first moved to the barn when Nappers Stores was still a grocery
Could
shop.
you kindly speak up a little bit, please? Thank you.
I first moved to the barn when Nappers Stores was still a grocery shop, followed by Burger Beauty taking over the premises. I had a good relationship with both business owners, and I hope to be able to continue in the same way with any new tenant, just as the applicant would like to have good relations with their neighbours. I'm not somebody who enjoys confrontation. I'm no protester. So this is way out of my comfort zone. However, I do live in very close proximity to the site in question, and the shared access drive is the only access to my house, which makes this very important for me. The main reason for submitting my objection was the lack of information provided around the proposed wine bar. Our first indication anything was happening was the licence application going up in the shop window, followed by the planning notification in the post. I appreciate that we do not all approach things the same way. In the past, I've always consulted and talked to anyone affected before submitting any planning application, but I understand that was my personal choice to do so. The lack of contact and information in this case has only increased the amount of worry generated by the lack of detail available, and maybe indicates that the applicant and the landlords realise that there's big problems associated with the new business. Opposing the proposals as they currently stand has been the only way to find out more details about them. I totally understand there needs to be a premises in the business, and the landlords will be keen to have a tenant, and nobody wants any more empty units on the high street. However, a village high street is also a residential area, which some people might forget. And the proposed licensing hours exceed anything we might have expected. I'm very concerned about the personal neighbourhood impact of the business, particularly late in the evening, from the point of view of noise and public nuisance. Maybe surprisingly, Nappers is generally a very peaceful place to live. There's bound to be a certain amount of noise from the high street during the day, but the evenings and the nights are generally quiet. As I said in my submission, my bedroom is very close to the shop parking space, as it is in the closest part of the house to the main road. I can't soundproof a glazed door or a Velux window, both of which face directly onto a parking area. I'm concerned that even if customers attempt to leave relatively quietly out front of the building and staff in the rear, it's very difficult to enforce, and I could additionally be woken by the car leaving every late opening night after the bar has been tidied up and closed. The drive is gravel, so even if the car doesn't wake me when starting, it will when it crosses the gravel. I welcome the fact that we've had a bit more detail about things like deliveries. I'd like more detail about how the waste will be managed. I know one letter of support states that the waste will be managed at the rear, so not just to impact on residents' lives. Unfortunately, this gives me no comfort as my home is behind the sign, with my bedroom the closest to bin area, and that's where my neighbour's outside space is. There may be a very sensible plan for all of this, but we don't know what it is, and I want to be sure that emptying glass into bins anywhere at the rear will not take place other than during reasonable hours. The same goes for deliveries. I note that we've been getting more details that today, and that they will be at reasonable times, but I'd like to know more details about when and where these could be expected. Because part of my teaching job is home-based. My pupils need to address my driveway at various points of the day. Therefore, potential van blocking access, even in the shared drive area, would be problematic, not least because reversing back onto the high street is dangerous for vehicles and pedestrians. The assumption seems to be that we're all out of the shared area during the main part of the day, but my hours are varied, different every day. Hence my worry that I may find access blocked at times or blocked for others who may be needing it. Plans submitted seem to suggest that there's a yard and a turning area at the rear. In reality, there's space for 3 allocated cars to park, which just leaves enough room for them to turn, which is difficult or impossible in a larger vehicle, or for me to pass. There's not room for anything more other than by blocking the drive, trespassing on my private land to turn, or worse, parking on it, which has happened. Further on the topic of public nuisance, I really appreciate Mary's comments on controlling the effect of parting customers would have on the surroundings. Although once they're beyond the door, it's difficult to have jurisdiction over them. There's also the issue, though, of customers wanting to smoke, vape, or get fresh air during their evening in the bar. There's no width of pavement at the front to accommodate this, so I fear they will be using the driveway, as it will seem a logical place for them to go. I know the comments about CCTV, but obviously CCTV can't just be put on a listed building either. If the chosen venue had outside space, this would be a lot easier to manage, and it would also give space for people to evacuate to in an emergency instead of into our shared access, assuming that that's where the fire point will be, but we don't have any details about that yet. The application states that having a new licence will be a good continuation of the licence held historically by the premises. The reality is that this was a licence for a very different purpose. We would not be so concerned by the prospect of it covering limited purchases as part of shopping at a general store, which was the case previously, or by a bottle shop alone. Consuming alcohol on the premises and becoming a hospitality space rather than the retail space is a very different proposition, with a vastly greater impact on the adjacent buildings, which has led to our considerable worries about the prospect as it currently stands. I'd urge the panel to consider the issues a licence would potentially create in this location while reaching conclusions. Thank you.
Thank you very much. Are there any other people attending online or in person who wanted to make representations? No. In that case, I invite members of the panel to ask questions of any of the people who have just spoken.
Could I ask the applicant why she hasn't previously engaged with the two neighbours?
If I'm honest, it's the first time I've done something like this, and I didn't actually realise that it was legal to do so. I thought protocol was to go through the legal route, and I didn't feel it was right to knock at someone's door and just say who I was and literally knock at their personal, into being their personal space. I thought that would be considered cold calling, and a bit like Virginia, I'm not a person that likes conflict, and I if I'm honest as well, in terms of legalities, I wanted to make sure everything was documented that could possibly be brought against me or put forward. But if in brief, I don't think it's right to knock at someone's door beforehand.
Fine. What does the legal? Sorry, no, can I just be clear on that? Is there anything?
There's nothing to stop somebody engaging, but that I can understand.
Yes,
why the applicant might feel that it was more appropriate to go through the recognised channels. There's nothing to stop somebody approaching, and it's quite common in planning or licensing for people to engage with a neighbour or neighbours in relation to something they're proposing.
I think if I was in situ already and changing something, I would then feel that I knew the neighbours and could go and speak to them as a neighbour, but not knowing who they were, or I wouldn't personally want to walk into their house and not, feel safe not knowing who they are, or as I say, into their personal space and knocking at a time that was perhaps inconvenient.
Thank you.
Yes, okay.
So it's questions for the speakers now. Kelly, did you have any questions for any of the speakers? I've got a question for Mr. Holland. I think you wanted to say something, so my question is, what would you like to
do? It was obviously, I appreciate Mary's concern about sort of coming and knocking on doors. That's fine, true, I totally understand that. But I thought that there was a process of mediation, and maybe that could have been part of the mediation through the council, that we could have. Obviously, there was some. Obviously, we sent our obligations. We waited 3 weeks for a response back. I thought that mediation could have been in that process.
It's just to be clear, it's not a mediation.
It's not.
It's and I appreciate you're also trying to navigate both on a planning front, as you've explained, and the licensing regime, which are two very distinct regimes. It is an application that's put in both cases, actually, and a response time. They're different response times, and the strictness of how people, so what would tend to happen is that an applicant will put in their application. They will wait for those responses because there might be various aspects that those objections encompass, and therefore they would probably want to do quite a concerted approach rather than a scattergun approach to those, so that they're all documented. So it isn't a mediation, and I do appreciate that this is all new to you. Yes. It's not a mediation process. Where sometimes there is toing and froing is, I say, with environmental health or the police, for example, who are the statutory consultees, and that will sometimes involve some negotiation over potential conditions or objections and how those might be overcome. But in terms of the actual objectors or supporters in some cases, it's not a mediation as such.
I appreciate how difficult the process can be.
Yeah,
though, how-
just the word mediation is
Yeah, quite, no, and
Yeah.
when you're not versed in
No.
these procedures, it can be very difficult. Are there any other questions from?
Just were there any of the speakers in favour that actually live next to the site? Because I noticed that half of them didn't even put their addresses on, which I find concerning as well. So I was just so none of the people in favour that spoke in favour of it lived connecting to the site as the people that had objected.
No, not directly. I'm probably the nearest neighbour. I live just in Cleve Road around the corner. I walk past the High Street virtually every day, several times a day sometimes, but I'm not an immediate neighbour.
It isn't a requirement. No, I know it's not a requirement. It's just curiosity, which is perfectly fine.
But I did leave my name and address.
Yes, I know your name from Bloom.
Yeah.
If there are no more questions from the panel, does the license? Oh, sorry, go on. Kate.
Sorry, so slightly, I hope you're quick, Chair. Mr. Levy, could you just remind me the name of that report, please? I'm quite interested.
Oh, yes, it's called High Streets, Life Beyond Retail, and it was published on November 28th, just last month.
Right, thank you.
So if there are no more questions from the panel, does the licensing officer have any questions? Applicants first, sorry. Does the applicant, I beg your pardon, have any questions for any of the speakers?
No questions.
Thank you. Does the licensing officer have a question? Thank you very much. Well, that concludes the presentation stage of this panel, but we'll now move to the final submission stage and ask each party if they wish to summarise their view before we go into closed session to make a decision. And we start with the speakers, don't we? With the other parties. So would anyone like to make some final representations in summing up?
I think she's
Sorry,
but I don't have any final submission.
Go ahead, Ashley. Is there
I don't have any.
No,
final submission.
fine.
Thank you very much.
The applicant concludes though, don't they? Yeah. So would any of the speakers like to sum up or raise any? Yes, Mr. Holland.
Well, I think I'll just summarise this. Just again, it's a grade 2 listed property. Would any of you want a wine bar underneath your bedroom? I think the property is unsuitable for the wine bar element and the timings of until 11 o'clock for the 4 days a week. That's my summary. Thank you.
Did the applicant want to make any statements in summing up?
I do. I don't know.
No.
It's just this. This is one of several stages. You've heard licensing, planning, listed building. So the focus for you today is not, is there a risk of a private nuisance being created to the immediate neighbours? Question is, what is the evidence there will be a public nuisance affecting a sufficient number of people in the area? And the answer is there's none. There's no evidence suggesting the grant of this application will create a public nuisance. The environmental health officer, who didn't make a formal representation, but we have engaged with, agrees that with the additional conditions we've proposed, I quote from your own environmental health officer, that is a sensible position to be in. So in other words, no objection in principle, but the details of what works need to be done is something that need to be discussed and need to be approved by the environmental health officer before we can operate the licensable activities. But it will also be the focus, I imagine, of the planning application, just a separate jurisdiction. There's no evidence this application, if granted, will undermine the crime and disorder objection, and the police not objecting is the strongest evidence for that. So we say that with those additional conditions, there are no reasons to reject this application based on the licensing objectives. There are additional measures I can propose in response to what we've heard from the two objecting residents. In regard to putting out waste, we acknowledge if we put punky bottles out late at night, that can cause a problem. So we can undertake by way of a condition that no waste is to be placed outside between 6 p.m. and 9 a.m. So that matches the hours of no deliveries. The waste will be kept inside, and we anticipate waste collection will be around 10 a.m. It means there won't be any disturbance to the residents by the waste being put outside at night. To deal with car parking, the overwhelming number of customers are expected to walk there. They're going to be villagers. So we're not expecting many cars. There is a space behind the shop, but there is also a public car park about less than 100 metres away down the alley opposite. Smokers, once again, we're not expecting smokers. The clientele we're used to don't tend to be smokers, but if there are someone who wants to go out to smoke, they will be directed to do it down the road. There's a park bench about 30, 40 metres away, and they'll be directed to go there. They won't be permitted to smoke bang outside.
May I ask a question? Is that conditionable?
It is. We could add a condition that customers shall not be permitted to smoke immediately outside the premises.
But can I just ask how that would possibly be enforced? How the owners of a private business are going to enforce smoking outside that business? That
Enforced
they
in the
don't
same
know.
way as the no rubbish, no noisy bottles. I mean, all of these things.
If I frequent, what I'm trying to say is, if I go to a bar and I step outside of that bar onto public land, be it the entrance of a driveway, the road, the pavement, and the owner of the business comes out, they have absolutely no right over what I'm doing. They can refuse to serve me back inside again, and I'll say, okay, well, I'm still going to enjoy what I'm doing here. So that's what I'm saying. How can the owner of the business possibly enforce something on private land, on public land? I don't understand.
It comes in exactly the way you just outlined. But
By saying they can't come back in, but they're not going to actually enforce it at all. They're going to say she can't come back inside. So it's keeping the person outside for longer.
It's not. Firstly, it depends the sort of clientele we're expecting. We're not expecting confrontational clientele to turn up. It's not a nightclub. It's local villagers. But if someone goes outside, they will be asked to go to the bench. If they ignore that direction, they'll be told they cannot come back in. So they're no longer our customer. And there's no point in them standing outside smoking because they won't be allowed back in.
Okay. Thank you. Sorry. Did you have anything else to say?
I didn't know I didn't.
So there was the additional condition that you're suggesting around smoking.
Yes.
You mentioned the public car park, but you didn't say whether there would be a strict ban on clientele parking behind the premises.
Well, Mary, what will you do?
Absolutely no, there's no space for them. It's one space only. You won't be able to park them.
Will you be able to put that? That's on your website.
Yes, I mean, it's going to be an informative rather than, because I'm guessing the car park is actually controlled by the general management. Yes, you will have access to one space from the sounds of it.
That's back round the back of the
Round the
business,
back.
as opposed to in the car park. So the car park
Right.
is out the front down an alleyway, and the one parking space is round the back of the business,
Which is
but it won't be
Yeah.
accessible to any customer.
Thank you. Thank you very much. I see that there's a gentleman with his hand raised. It's quite unusual. Are you one of the listed people?
Yes, I am. My name's Stephen Goss. I've had the pleasure of working with Mary at the Murray Mansfield for quite some time.
Right, okay. But is there anything?
I just want to follow up on the ladies. She's speaking about how you can control outside what goes on. I've worked in pubs for many, many years. It's the relationship you have with your customers. You are in complete control.
Yeah, I grew up in pubs. I'm fully aware. Thank you. He has
Thank you very much. Okay, thank you for that. So I think that being concluded, that is the end of the proceedings for now. So we will ask you now if you could leave the room, pop over to Waitrose where there's a cafe, take your time. We'll be deliberating for
It takes.
however long it takes. I would imagine an hour or so, but yeah. And then we'll call you back in when the time comes. But please stay close.
Are we safe to disappear until 1:15?
What's the time?
22.
I think you are safe to do.
So if-
Really? Yeah, I think that's. Well,
So 1:15 at the latest.
At the
then,
very
so-
least.
Can we say one would be better?
Yeah.
Yeah. I wouldn't get back to the other side as strict as I am.
Thank you very much.
Yeah.
Right, well, I should ask, does everyone feel they had a fair hearing today and that their views were heard?
Yeah.
Yeah.
Yes, thank
Okay, thank you. Thanks, everybody.
Bertie, could you pause the stream, please?
Thank you very much indeed, everybody, for returning, and apologies for the delay. Following discussion with my fellow panel members, I can confirm that a decision has been reached. The panel hereby refuses the application for a premises licence for Napper's store High Street Goring on Thames. Please be aware that a full decision notice with reasons for the decision will be sent out to attendees once we've processed it. The document will be sent out electronically unless a paper copy is specifically requested. Any party may appeal against the panel's decision. Any appeal must be made to the Magistrates' Court within 21 days of the date of this decision notice. This has to be made in the correct manner, accompanied by the required fee. In the event of an appeal being lodged, the panel's decision remains valid until any appeal is heard and any decision is made by the Magistrates' Court. Thank you very much indeed for your time today, and I thank you for your attendance. And I hereby close the meeting at 1:47 p.m.
Thank you.
Thank you.
And I just